Hi there. Thanks for the introduction. I'm really happy to be here. This is hopefully going to be an interesting talk. I've titled it Hacking the Patent System. It's different from the EFF paper called Hacking the Patent System. Basically, so my name is Charles Dwan. I am the director of the Patent Reform Project in an organization called Public Knowledge. We're an organization that does DC-based advocacy on technology and policy issues. And so I noticed that we have kind of two patent talks back to back. There's another one at 4 o'clock. And that one I think will go into some more of the really specific laws. But I want to use this talk as kind of an appetizer to, what's your appetite in terms of, what are the problems with the patent system and what exactly is going on. And, the one thing that I'm pretty sure most of you have heard of are patent trolls. These are people who, they take these really silly patents on, sending emails or scanning documents, and they make these outrageous demands. They say, like, you have to pay me $1,000 if you use a scanner, or you have to pay me $100,000 if, you send email in this way. And they send these, to a lot of these really small companies that can't afford to fight them. And kind of to top it off, they don't make anything. So, you've got these companies going out there saying to all of you guys, you're not allowed to write computer programs or do all the cool stuff you're doing, and we're not going to give you anything in exchange except for demand letters. This is besides patent trolls. I think a lot of you have heard about some of these patent wars, like the one between Apple and Samsung. These involve more silly patents. Some of the ones on rounded corners you've probably heard of. You've probably heard of the Amazon patent on photography against a white background. So there are a lot of things going on that I think make people in our community think there's something really wrong with the patent system, and there is something really wrong with the patent system. But the other thing I get when I talk to people in these sorts of groups is this sense that this patent system is this arcane thing that I can't understand. I don't know what's going on with it, and I don't know what to do. And it's sort of the sense of hopelessness that there's no way to fix this thing. And this conference is called Hope, so I am here to give you hope. There is something you can do to fix this. With your help and with your work, we'll be able to actually make it better. But in order to do that, we first have to actually understand what's going on. Now, I don't imagine that too many of you do much work in legal policy, but I do imagine that a lot of you know about security. And the way I would encourage you to think about the problems with the patent system is like a security vulnerability. The patent system is basically like a computer system, right? It takes certain inputs, patent applications. It does some processing on it. The patent examiners do some examination on it, and it produces some outputs. It produces patents. And a lot of times, this works okay, and you get the data that you're expecting. And a lot of times, people figure out ways to send carefully crafted data that gets out results that you're not supposed to be able to get, namely the kinds of silly patents on rounded corners or sending emails. So I would encourage you to think about some of the problems in that way, to look at the ways that people are taking advantage of the system in order to get things out of it that they're not really supposed to get out of it. And so, to start off figuring out what that is, we have to look at, how is the patent system supposed to work? The way it's supposed to work is that patents are an exchange between the inventors on the one hand and the public on the other. The inventor, they invent something, they create something new, they spend a lot of time, figuring out how they want to make this product work and how to get it to be useful, and they provide that information to the public. That's the inventor's part of the bargain. And in exchange, the public, through the government, gives the inventor certain rights, certain monopoly rights. They say, all right, since you invented this, you get this patent, you get to do all of these special things with it, and you get to keep other people from doing that. So this is meant to be kind of an equal bargain. The inventor has to provide something, the public provides something. And when we look at, what's on both sides of the bargain, the person who receives a patent, they get a lot of rights. You get to, if you own a patent, you get to keep other people from making, from using, from selling, from offering to sell, and selling includes giving away for free, so even offering to give away for free, from selling parts, from telling other people how to use an invention, from importing an invention into the United States, from exporting parts of the invention out of the United States. These are a lot of rights. If you hold a patent and you see somebody else doing any one of those things, you have a reason to go after them and sue them for potentially a lot of money or to tell them to stop doing it. So the patent is a very, very powerful thing. And in exchange, the patent owner is expected to do a lot of work in order to get that patent. So the person has to invent something. That invention has to fall within certain categories of what is allowed to receive a patent. They have to come up with something that's new. They have to come up with something that's non-obvious. These are these are supposed to be pretty hard tests. There are a lot of things that you and I would know how to do. You're not supposed to be able to get patents on that because it would be considered obvious. You have to file this really detailed patent application that explains exactly how the thing works, exactly, all of the aspects of it. You have to put in all these drawings. It can be a very expensive and very complicated thing to put together a patent application. And then you have to go to the patent examiner and go through, 2, 3, 5 years of examination and, explain to them why this invention is really interesting. This is a lot of work, and it demands that you have some sort of really good invention. So that's why we feel it's okay to provide all of these really powerful rights on the left, because you have to do all of that work on the right, and you have to give something really useful. So that's how it's supposed to work. But if you want to take advantage of the patent system, your goal would be to try to get as many of those rights as you can on the left side without having to do any of the work on the right side. So we want to see, how do you do that? And the example I'm going to give you is I'm going to show you how to get a patent on this. Okay, this is a 3-line computer program written in BASIC. I'm pretty sure most of you can figure out what it does, but just for people who are only listening, this is a program that compares two numbers. If one of the numbers is less than the number, then the program stops. Otherwise, it subtracts and it adds two numbers. That's it. All right, so obviously you're not supposed to be able to get a patent on that, right? This is a mathematical formula. This is really simple. All of you probably do this all the time. So how do we get a patent on this? Well, first of all, I need to flesh out this program a little bit because this thing wouldn't really work right now. So I'm gonna. Okay, so sorry. Before we talk about that, the way I'm gonna do this is I'm gonna take advantage of a number of cases, and I'm gonna sprinkle the case law in here. And the first case I'm going to start with is this one called Diamond versus Deere, which has a line that says claims have to be considered as a whole. A claim is a part of a patent that defines, what you think you invented. And this is the part that the courts are going to look at, that the lawyers are going to look at. This is the part that's important to your patent. And the goal is going to be to make this claim as a whole look really complicated, even though it's really only covering this 3-line computer program. So how do we do that? Okay, first of all, I'm gonna say, instead of just saying just random variables, I'm gonna give the variables some names. I'm gonna do this in the banking sector context. So I'm gonna talk about an account. I'm gonna talk about two accounts. So you've got account 1 and account 2. And I'm going to change the variable to exchange. So basically now this is just a little program about exchanging money from one account to another. Everybody see how that works? This should be pretty straightforward. I'm pretty sure that most of you have done this at some point in your life if you've exchanged money with somebody. So we need to declare our variables, right? That is kind of how computer programs work. So we need to do that. Let's put in an input-output statement so that we actually, receive some data, because, you need to know how much money to exchange before you can exchange the money. And, I'll throw in a couple print statements just so, we know what happened. As you can see, all the things I've added, these are just, very conventional things that you would ordinarily do in a computer program just to get the thing to work. Lots of law out there saying that adding these sorts of steps doesn't contribute anything to patentability. And I think all of you would understand that, adding a couple of print statements shouldn't make something patentable. So here we got this computer program, which I've just fleshed out a little bit, but it really is that same program. So starting from here, let's go for writing some real patent language. All right. So we're going to start out with a computer system. We're going to talk about computer system. Computer system, that doesn't sound so complicated. Let's call it a data processing system. Data processing system. What does a data processing system have? Well, it's got a keyboard and it's got a keyboard controller. Something to receive the data for the keyboard. But keyboard, that's kind of a conventional term too. Let's call it a communications controller and a first-party device. Because that sounds a little fancier, right? First-party device, and now, maybe we're talking about some network stuff. It sounds better. Okay, so we've got communications controller, first-party device, coupled to said communications controller. What else does a computer have? It's got a memory, right? But memory, that's kind of conventional. Let's call it a data storage unit, and it's got a CPU. Instead of calling it a CPU, we'll call it a computer, but we'll also mention, by the way, that the computer is coupled to a said data storage unit and said communication controller, just in case you weren't sure that your CPU was connected to your keyboard, right? All right. So now we've got this, and this is a lot of text just to explain what a computer is, right? So why are we spending so much time just explaining what a computer is? Well, it's because we have a number of cases out there. One of which was this case called Bilski versus Kapos. I'm just quoting something out of the Patent Office's guidelines, which says that recitation of a machine or transformation, either express or inherent, weighs in favor of patent eligibility. So that means that if you're talking about a machine, it sounds a whole lot more like it ought to be patentable than if you just talk about an equation. So the more I make this look like a machine, the better a place I seem to be. So as a result, I'm going to spend a lot of time just, explaining, okay, what parts of a computer I have, even though these are all just very generic parts of a computer. All right, so let's move on to what this computer actually does. So you remember we declared our variable, so we'll have a data storage having stored therein a first account balance and a second account balance, right? That reflects the two lines I got there. But first account balance, second, that makes sense. We can't use words that make sense. So we're going to say information about a first party, or information about a first account for a first party, and information about a third account for a second party. But we can flesh that out even more. We can say that the information about the first account for the first party is independent from a second account maintained from a first exchange institution. And the same thing about the second account. Now, all that says is that the information that I am storing in this computer is also somewhere else. Right? All I've said is that, this information in the computer, it's also on some other computer. It doesn't add anything to the actual operation of the computer. It doesn't add anything to the complexity of the system. It just says, this is what the data happens to be. There are a lot of Supreme Court cases that say, this stuff doesn't matter. But it makes the thing look really long, so, we like it. All right. What else can we do? Okay, now we're going to get this input statement. So you remember I had this computer that was coupled to the data storage unit and said communication controller because, apparently we didn't know that computers were connected to keyboards. What does this computer do? So we're going to spend a lot of time talking about this very simple algorithm. And the reason for that is that there are a couple of cases that are out there that say that if you spend a lot of time explaining an algorithm, that algorithm turns the computer into this special purpose computer. And because it's a special purpose computer, now suddenly the thing is patentable, whereas a general computer is not. So, there's one case that was actually decided just last year that decided that a patent was, perfectly eligible, and the reason for that was that it required it had a lot of steps, and these steps required intricate and complex computer programming. Now, if any of you actually read that patent, I'll give you a little background on this one. This was a patent on the technology of displaying an ad before watching a video online. How many of you think that that requires intricate and complex computer programming? Now, the lights are off, but I'm pretty sure there are no hands up. Yes, lots of problems there, but we're going to try. We're going to try to make this thing look like it requires intricate and complex computer programming. So how are we going to do that? All right. We're going to receive an exchange amount from the keyboard, right? That was the first thing that we did. We received some data from the keyboard. Receive an exchange amount. We're going to say receive a transaction, because transaction, that's kind of a fancy thing, right? And this part about being from the keyboard, remember we didn't call it a keyboard, we call it a first-party device. And just in case you forget, we're going to receive it via the communications controller. So now we've got the actual steps of of comparing the data. And so a simple way of explaining that, which I put up on the screen, is we adjust the accounts based on the transaction. We call it a transaction, so I'll call it a transaction again. If the accounts have sufficient balances, right? So we're going to do a comparison to see if it has the accounts have sufficient balances, and then if they do, we're going to adjust the accounts, right? This makes sense, which means that we have to fix it. Instead of saying just adjust the accounts, let's say electronically adjust the first account and the third account, because instead of just saying accounts, we can list them, and that adds more words. Based on the transaction, that's a very simple way of saying things. Let's say in order to effect an exchange obligation arising from said transaction. You see, I've introduced this new term, right? Exchange obligation. What's an exchange obligation? Well, you have to do the exchange. Well, what's the computer going to do? It's going to do the exchange. So all I've done is really introduced a term that describes what is happening. Again, it's not any real substance to this, but it does make it seem like there's more going on. And then, I'll mention again that it's between the first party and the second party, simply because I can. And then this part about if the accounts have sufficient balances, that's again, very simple. So instead, we're going to say, after ensuring that said first party and or said second party have adequate value in said first account and or said third account, respectively. Read through that again, and you'll notice that all that's really saying is just compare two numbers. But, this sounds like it's a pretty complicated operation, because of the fact that they say and or there, which, means that you could do it that way, or you could compare some other numbers. It sounds like there's more meat to this. But really, all we're talking about in, this half page of text is comparing two numbers. That's what I've got in line 40 over there. And then if the comparison succeeds, then we decrement one account and we increment the other account. And then finally, we've got this print statement, which is we just print a message about the amount that's being exchanged. And so what I've written over there is just generate a message about the transaction. But instead, this is actually a good audience participation time. Does anybody have a thought for what to say here? You can just yell it out. Come on, just make up something. Tell me something. Tell me something that you would say to make a print statement look fancy.
Generate an electronic output chronicling the details of the transaction.
Excellent. Generate an electronic output chronicling the details of the transaction. In a human readable format, I like it. Anybody else? Wait, somebody said electrons, which means we actually got physics into this thing now. All right. All right. The actual thing they put in here is generate an instruction to said first exchange institution and or said second exchange institution to adjust said second account and or said fourth account in accordance with the adjustment of said first account and or said third account, wherein said instruction be an error. I can't do that. wherein said instruction being an irrevocable time-invariant obligation based on said first exchange institution and or said second exchange institution. All right, anybody thought they could come up with that one? Nope. All right, this is why they pay the lawyers the big bucks, right? All right. It actually sounds like there might be something more going on in there. So, let's take a look at what's going on exactly here. Generate an instruction to said first exchange institution and or said second exchange institution. Well, we're just saying, where the instruction goes. And, if the print statement is read by the right person, that's where it went. So, again, that first part, it really just says what the data is used for. It has nothing to do with what the computer is doing. To adjust said second account or said fourth account, that's just talking about what the exchange institution should do when it receives it. This patent claim, it doesn't actually say the exchange institution has to do anything. It just says the instruction has to explain that. And you'll see in the print statement that I have there, it just says, here's an instruction to the institution, do this. And everything that you read in this patent suggests that that's enough. In accordance with the adjustment of said first account and or said third account, well, I just printed out the amount that's exchanged. That's that. And then this business about wherein said instruction is an irrevocable time invariant obligation placed on said first exchange institution and or said second exchange institution. Now, that sounds a little bit like, there's some sort of database locking going on here. And if there were some database locking going on in here, I would actually say that's kind of an interesting thing because database locking is a very hard thing to do. Coordination among different threads, that's a pretty complicated thing. And if they talked about like different methods of locking databases, that could actually be kind of cool. But you read through the patent application, they don't say a thing about it. They just say, well, people know how to lock databases, so just tell them to. And I mean, so if all we're doing is we're just saying, do this, then if I just say, here's an instruction, and by the way, it happens to be irrevocable and time invariant, and you happen to obey that, then the implementation behind that is kind of irrelevant. And as far as the patent application goes, from what I've read through it, it doesn't seem to require any special way of doing that. It doesn't seem to require any particular database technology. As far as I can tell, really all they're requiring there is just telling somebody, by the way, this happens to be the way I want it to be. So really, I think that all of this text more or less boils down to just one print statement. But you see just how much stuff I generated out of that. Right? And, all of you guys, you came up with all sorts of other things, and, that's basically what happens in a lot of these patents. We hear a lot about the patent on, scanning documents to emails. And, when you read through, like, the title of the patent application, and if you actually spend a lot of time figuring out what's going on in the patent application, in that one, I've done this, I did this a couple months ago, it does turn out that all they really are saying they've invented is scanning something in email. But they don't write a patent claim that says scanning to email. They write some huge behemoth like this that sounds like, you're doing all of this fancy one-touch, automatic processing, all sorts of things. And I think what happens is that it tends to impress a lot of people. But when you actually get down and think about what they're talking about, it really doesn't amount to much. I mean, sorry, I keep hitting the wrong button. Here's the entirety of the patent claims that we just talked about. This is a lot of text. This is a lot of text to explain what is basically this 7-line computer program that really amounts to the 3 lines I showed you before. And that's basically what you see in a lot of these patents. One of these days, the next time you see one of these patents that somebody is talking about, they're saying this is a silly patent on photography or something. Jump back to the end of the document. Take a look at it, and just look at how much they've written. You may be able to understand, you may not. There are a lot of fancy words that get thrown around in patent claims. But if you really spend the time to understand it, you'll often find that they are much simpler than their length would suggest. So, okay, now I get to show you the slide which I kept accidentally showing you. That thing that I just showed you, that's an actual patent claim. This is the patent that it came from. This is a patent by a guy named Ian Shepard. It's owned by a company called Alice Corporation. Some of you may have heard the name Alice Corporation because that is the name of one of the parties to a recent Supreme Court case called Alice versus CLS Bank. Many of you have probably heard about this case as, not completely eliminating, but making it much harder to get software patents. That case decided basically that, all of that fancy text that I just showed you, even with all the discussion of computers and everything, really amounted to nothing more than, a basic equation, or really just a basic method of, conducting financial transactions. And as a result, it wasn't eligible for being a patent. And, the Supreme Court figured this out. But, think of how much work it took before the Supreme Court got to that point. Alice filed for this patent application. They went to the patent office. They convinced patent examiners that this was a really complicated and interesting thing. They convinced the patent office of this, I think 6 or 7 times. They have something like 6 or 7 patents on this technology, all of which are really long and detailed. And all of which more or less talk about the same thing. And then, they get their patents, and then they go off and they start asserting their patents against one of the biggest financial companies in the world. They get involved in, I think, 3 or 4 years of patent litigation, and they convinced several courts that, this thing is valid, and they convinced 5 out of 10 judges on the lower appeals court that this thing was valid and that they ought to be able to get a patent on it. And then, they go to the Supreme Court, and I went to the Supreme Court to watch this case being argued, and the justices had stacks of the briefs on their desks, and the stacks were something like this high, right? This is how much paper was written over it, just to explain what was going on in these patents and why was this bad for, the economy and people. And, only after all that work did the Supreme Court finally, explain, no, this is not actually any super awesome thing. This is just adding numbers to a bank account. This happens all the time, and most of the cases don't get to the Supreme Court. It's unfortunate, but it's the case. Very few, almost none of the cases will get to the Supreme Court. Almost none of the cases will get to even an appeals level. And the cases that get to an appeals level are a tiny fraction of the cases that are just fought in the trial courts, and the cases that are fought in the trial courts are just a tiny fraction of the demand letters that are sent out to small companies or people who are just using technology. So there are a lot of these things out there. This is a very well-known technique, and a lot of people have been using it. So I guess the question then is, that's the exploit, so what's the bug? And I wrote a little article about this. If any of you are interested in reading works of fiction on how the patent office works, this is probably the only article on this subject. This is a story about the Amazon white background photography patent, which I imagine a lot of you have heard of at some point. Basically, it's a patent on a particular way of arranging an object and the camera and the lamps and things, so that you get photographs with like a nice white background. And a lot of people complain about this, but what I did at some point a couple of weeks ago was, I went through the patent. I went through, again, very long claims and figure out what is going on here. And what happened here is, I'll cite another piece of law here. There's a case that was decided just a couple weeks ago. It was a case about hearing aids. I'll tell you about this case. This is kind of interesting. It's a case about hearing aids, and the company that had the patent, they said, we've got this patented hearing aid. They're suing all these other people, and one of the other guys says, well, actually, we found this other hearing aid that predates your hearing aid by like 5 years. So remember that new non-obvious stuff? Like, you shouldn't get your patent. The patent office agreed with them, the board agreed with them, and actually, even the appeals court agreed with them. But the patent owner, the person who owned the patent on the hearing aid, they had another claim. And this other claim said, oh yeah, we got the whole hearing aid, and it has a plug. Just a plug. Actually, they didn't describe it as a plug. They described it as a multi-pronged electrical connection for transmitting data or something like that. The patent examiner, when they actually saw this the first time around, they said, "That's a plug. You can't add a plug to a hearing aid and suddenly get a patent on that." But then, when it went up through the chain and when it went up to the appeals court, they said, well, the examiners just said that, but the examiner didn't show any evidence of that. The examiner just, said this was out of common sense. And the board cannot accept general conclusions about what is basic knowledge or common sense as a replacement for documentary evidence. So basically what they're saying is, unless you actually have like this piece of paper in front of you that says hearing aids have plugs, you can't just use your common sense to know that you could add a plug to anything. And as a result, their patent stood up. Not the part about the hearing aid, but the part about attaching a plug to it. Because of the fact that, the law requires this sort of very, very stringent evidence.
They paid off?
Who, the judges?
Yes.
Well, I'm not going to make fun of the judges other than to point you to the recent ethical scandal about Judge Randall Rader, which is probably unrelated to this. One of the issues that we do see, just more generally, is there is this very kind of cozy relationship between a lot of among the patent bar and among the patent office, and among among the people who decide these sorts of things. So I'm going to jump ahead to this slide. So this is kind of getting into the problem of what can we do. There are a lot of opportunities for us to explain what's going on, but the problem is that who is talking to the patent office right now? How many of you know that on Tuesday the patent office is holding a public meeting to discuss software patents? I thought I saw a hand somewhere up there. I think I see one hand. Okay, so good. There are a couple of people. You should all know this. There's a public meeting to discuss software patents. There is currently a rulemaking. There's currently not a rulemaking, but a request for public comments on how to decide what patents are eligible, particularly software patents. There are a lot of opportunities actually to give input to the patent office, but the fact of the matter is that when the patent office provides one of these opportunities, they send it out to the mailing list, and who's subscribing to the mailing list? It's the patent lawyers. So the patent lawyers will all show up to this meeting on Tuesday.
Public knowledge.
And me. Because of the fact that this has become such a big thing, there will actually be a number of people who are working on the patent reform side who will be showing up to this, and I think that's good. But I think the thing that we really need to show people is that this is a huge community of people who really care about about technology and about the ability to create and develop and make new things. There's a sense, I think, among a lot of the people that are very within the patent system that patents are an incentive to creating inventions. There doesn't seem to be much else, so therefore patents are the only incentive to creating inventions. So therefore, the only thing we should be doing is making patents as strong as possible because that'll get us the most inventions. Now, I'll bet that a lot of the people in this room have invented something, probably something that is worthy of a patent. And I'll bet that a lot of you have not filed for a patent application on it. Why? Because, we invent things for other reasons. We invent things because they're cool, or because it's fun, or because it's useful, or because, I want to show it off to my friends. The whole open source movement is based on this, right? The idea that I make things because they're useful and they benefit the world. Not because I'm going to make a lot of money off of them, or because I'm going to demand, that long list of patent rights. that you get from having a patent. There are lots of reasons that people make things. Even the for-profit startup community, they build their technology as fast as possible, not because they're hoping that they can take over the market through patent rights, but because they're hoping that by being fast and being agile, they can create a whole new industry, like the next Facebook or the next Twitter. There are lots of incentives out there, but the incentives that get talked about whenever I go to the patent office and whenever I talk to patent attorneys it's just patents. It's, we need more patents because otherwise we won't have more inventions. And a lot of times that tends to be the message we get. The thing is that the people who will give the real message that's, no, there are lots of reasons that we make things and sometimes patents get in the way of that, those people are in this room. Those people are the people who often are saying, I'd really just want to be making stuff. You have to be telling that to some of these, to the people who are decision makers. I said at the beginning that we we should think about the problems with the patent system as kind of security exploits, and one of the places where that analogy breaks down, this is one of my favorite XKCD comics, which I think is tangentially on patents. One of the places where I think that incentive breaks down is that normally when you report a security vulnerability, everybody agrees that it's bad and that we should fix it. Now, sometimes there's like inertia, or sometimes there's a desire for the company to be secret about it, or not like tell other people that there's a security vulnerability. But I think everybody agrees that security vulnerabilities are problems that need to be fixed. Whereas when you get to basically bugs in the legal system that allow for things that are not supposed to happen, you actually have people who are in support of the bugs. Right? Because they make a lot of money off of them. So what's going on in this comic, if you can't read it, is this guy, he says, dude, I had this idea like some 5 years ago and some company is getting rich doing it. I want my cut. And he goes to this website called the Department of Ideas and said, I came up with this idea 5 years ago. And then, waits a couple of weeks and in the mail he gets this box of money. What I think has happened is that a lot of people have started looking at the patent system not as an incentive to actually go out and make stuff, but as kind of a lottery ticket. I file my patent application and maybe 5-10 years down the road, I'll just sit around and wait for other companies to make the same thing, and then I'll just go ask for my box of money. That's not really how the patent system is supposed to work, right? What I said at the beginning was patents are supposed to be information exchange for monopoly. The information that's being exchanged, with a patent like I just showed you, is very minimal. That's not anything that any of you didn't know, how to add two numbers. But they're going off trying to collect a lot of money, and because of the fact that they make a lot of money off of this, they have very strong incentives to keep the system the way it is. And they're spending a lot of time lobbying the patent office, saying, don't change the system, don't mess with it, don't like change the incentives or anything. They spend a lot of money going to Congress saying, if you mess with the patent system, like all the invention's going to go overseas to China or something. They spend a lot of time talking about this. And for many years, they were really the only voice talking about this, especially on Capitol Hill and, within the government. But recently, I think, some of the other people, including like some of the smaller technology companies, some of the like mobile app developers I've seen, a lot of the like non-technology companies, a lot of restaurants have been showing up in Congress saying, no, actually, these patents, they're actually not helping the economy, particularly in our areas. And so I think what we need to do if we really want to fix this, I can give you the specifics on, where's the right place to comment on, or where's the right place to submit filings, or where's the right place to write about this. But really it requires that, we all be active in pointing out how important technology is to us, and how important it is that we don't have patents that are getting in the way of, real invention and real innovation. So, I think I'll wrap up my talk because I see there's one question. Yeah.
So from the very meaning of the word patent, transparent. The original purpose of patents was to prevent knowledge loss through trade secrets.
Yes.
So in exchange for you tell us how you did this,
Yep.
and we'll give you the. When was this lost? The appears to have completely been lost in the debate.
Yeah. So that still is. I mean, it still is there. But the thing is that there are a lot of people, especially the ones who just have the patents right now, who want to say, well, patents are kind of like a property right. So, I've got them, and I really don't want anybody to be touching them. And you end up with this debate that ends up being very much over like economics and, like property rights and all these things. And they forget really about those basic principles, that patents are supposed to be a way of encouraging innovation and getting people to discuss their secrets and talk about how things work and not hide them.
Encouraging
Yeah.
innovation.
Yeah, they're about getting. Yeah, they're about getting Coca-Cola to give out the secret formula.
Isn't it the examiners who have really lost the program there, and not the people who are applying for the patents? Like, shouldn't a patent examiner take a look at an application and be like, okay, it's not good enough to say, oh, this application is, I'm trying to protect something I invented. That's not what it's for. It's like you just said. Why isn't the patent examiner evaluating it on that basis?
Yeah, so the idea is that those protections I said at the beginning, the new, non-obvious, that sort of stuff, those are supposed to be the implementation of it. That really gets to kind of the question of what's a good quality patent, and that's a discussion that is starting to be heard in Congress about what kinds of patents do we really want to be protecting? Do we want to be protecting all of these patents? Do we want a patent system that's just, you file an idea, and if the idea happens to be new, then you get a patent? Or do we want somebody to actually have to show that, no, this was actually a really useful thing? And that, so I think that the more that people are saying, look, we're trying, what we really want is for people to be disclosing trade secrets. And the idea that patents are just kind of this God-given right, really doesn't make any sense. I think that's a message that people need to be hearing more. I can't see who's holding their hands up, so can we get the lights on? Yeah. Is there a microphone?
Yeah. Hey. So I just had one question.
Yeah.
Where do you think, you mentioned earlier that these companies that are patent trolls, if you will, they don't actually produce anything? Mm-hmm. Whereas like Alice Corp, did they provide the software for somebody? And if not, where did the disconnect come where someone's available to create a program or create a product that they don't actually make, and then try to get that as a patent? Is that a historical? Has that always happened? We just see it more, or is that a disconnect that's pretty
so,
new?
the question of whether or not you have an obligation to actually make the thing that you have a patent on, kind of the conventional wisdom is that no, there's never been any requirement. You could always have patents without that. There are some academics who are kind of challenging that position, saying no, actually there was some law back in the day that said you actually had to make something. Really, the problem is not so much that it's not so much per se the fact that the company's not making anything, as if you're not making anything, your incentives are really weird when it comes to asserting your patents. If you don't make anything, you're not worried about being sued back. So you're going to do like all sorts of crazy things in the litigation because you're not really worried about your reputation. So as a result, you'll make the cost skyrocket, and you'll bring in like 1,000 claims into your lawsuit, and you'll do all sorts of things. And that's really what happens when we start looking at the activity of these so-called patent trolls or non-practicing entities. The problem is not the fact that they don't make anything. The problem is the fact that because they don't make anything, and keep in mind, because of that fact, operating companies can do the same things, right? They end up engaging in all sorts of really silly, pointless litigation abuse that doesn't really help anybody. All right.
So maybe it's a made-up stat, but I heard somewhere 30% of new patents can be shown to basically already exist as patents.
Yeah.
And thus, that seems like the major bug in the system, both to take advantage and to sort of show the ridiculousness of the system. So, are people doing that? You basically just look through all the patents, refile all of them with different language, get, a third of them approved, and then countersue the company suing you with the same patent.
So, I would be surprised if anybody is actually engaged in looking through old patents and trying to refile them, because discovery is a very intrusive process, and if one document slips out that you did that, you would be in big trouble. That being said, there's no requirement to do a search before you file a patent application. So, if you just think that nobody's done this, you'll file a patent application on it. And you probably have no idea that somebody did it. And, the real issue is, you may have two patent applications. I actually just saw this the other day. You may have two patent applications that really cover the same subject matter, but you saw all the words you can put in them, right? There's so much variation in language, it becomes really, really hard to figure out exactly what's going on and to make the assessment of, this is what they're really talking about once I figured out what all the complicated language is. And now I can actually do a real search. Part of this problem is that examiners have very, very little time to do their examination. Part of the problem is the hearing aid case problem, that you've got to find paper documentation of all the words, right? Even if the words are kind of meaningless or if they're just common sense. So those sorts of aspects make it really hard to get around this problem of you could have two patents basically on the same thing, but they look just different enough that it's really, really hard to make the argument that they're rejectable.
Do you know of a case where there two companies sort of countersued each other with the same patent, or maybe there was a single company that got sued by two companies, for very similar patents?
So off the top of my head, I can't think of any, but what happens a lot, what used to happen a lot, the law changed so that this doesn't happen anymore, but you could have two people who file patent applications near the same time, and they would get into what's called an interference proceeding, in which they're trying to decide who came up with it first. But of course, that depends on the examiner realizing that these two things are the same thing. Usually the way that comes up is that one of the attorneys finds out that this other company filed a patent application on the same subject matter, and the attorney will basically tell the examiner, by the way, I think that there's an interference here. So, most of the time when that sort of very clear duplicativeness comes up, it's because one of the attorneys noticed it.
If you had the power to completely redesign the patent system from scratch, what would your ideal patent system look like?
Oh wow, that's a long question. There's a very clever quote. I did hear somebody say no patents. There's a very clever quote from I forget who said this, that if we had to decide from scratch whether to have a patent system, we would say no. But if we had to decide whether to have a patent system since we have a patent system, then we would say yes. Basically, we have it because we have it. I think the one thing that would really help, that I can explain very quickly, is to make the proceeding more two-sided. Right now, the way it works is that you have an application, you go in there. It's the examiner. The examiner is often just like a recent college graduate. And then, 30-year patent attorney veteran, facing off. It's not a particularly easy fight for the examiners. The examiners have a really hard time dealing with that sort of thing. And I mean, you and I would too. So, getting more public involvement in there would, I think, be a really big step. The Patent Office has already started doing this. There's a new program called, why can I not remember what it's called? Third-party submissions, in which members of the public can send information to the examiners saying, "Hey, examiner, here's some prior art that you should read." And I think that more use of that program, kind of more formalization of it, and development of business models around that program, I think, are real potential opportunities for dealing with that. All right, next.
Hey, I'm from Freeside, Atlanta, but I work with medical research during my day job.
Yeah.
And I found that with the patent system, I know that that is where a lot of startups and a lot of money comes from. But the problem is that with some of the ideas we have, we're not necessarily able to get things moving forward because that whole patenting monetary thing now becomes a roadblock, like where nobody wants to move forward or invest time or money unless they know that there's going to be a patent down the road. Do you have any advice for people who are trying to make hopefully cheaper medical solutions?
Yeah, so particularly when it comes to like the medical pharmaceutical device field or medical device and pharmaceutical fields, a lot of the investors do kind of expect some sort of patent filings in there because they know that the regulatory path, you have to get FDA approval and all sorts of other things. They know that amount of time is going to cost a lot of potential lead time for the product, and so they think patents are a good way of dealing with that. This is one of the reasons that patents are actually useful, right? The fact that they provide that lead time. But it's difficult for a lot of smaller companies to achieve that funding. The Patent Office has developed programs to reduce the cost of doing these things. So they have these things called like provisional applications, and they have lower filing fees. Those are intended to try to help out some of the smaller companies where it's really useful. And I think that they're looking at other similar programs.
Thank you.
Yep.
You talked about that. Like, there's obviously companies that profit a lot over the bad situation of the patent system, and they try to defend the bugs in the system. But also there's also companies that are losing out. Like, I don't know how credible it is, like the big tech company, like anti-patent efforts, and they probably would like to, I don't know, they'd probably like the patent system to be better. How is there a way to like encourage these big companies that are on the losing side to take a more proactive effort rather than just like settle individually or something like that?
Yeah. So there are a lot of big companies that are very active, more so on the legislative front. I think that Newegg is famous for being the one company that won't. They never settle. They will fight every case, and so far they've been successful in every case. But litigation costs like $5 million per case, so it's really expensive. So a lot of them have turned to lobbying efforts and to talking to legislators as their preferred vehicle for trying to fix some of these problems. And in terms of that process, to a certain extent, you don't even have to go to the companies to get them to help out. You can do it yourself, right? You can call your senator and tell them, like, I want to support this. Just as a little background, there was a big patent reform bill that was moving a couple months ago that got killed off because of certain lobbying efforts from other lobbies. It'll probably come up again, so keep an eye out for that. And when that comes up, that would definitely be a good place to play a role. All right. All right, we got 1 minute, so I'm going to try to do this fast.
I'm just wondering how often, like, the claims like the ones in that Alice Court patent get through. Is this sort of just the sort of like, well, there's some examiners who aren't quite up on their game and the language is really complicated, or is this kind of more the rule than the exception, if you have an idea about that?
So I have seen a lot of them. I can't give you any, like, quantitative, I can't give you numbers, but I will say that this is a thing that a lot of people will do. Just putting in a lot of language to try to make it look really, really impressive. And a lot of it is just mandated by the law, right? It's not this isn't like an examiner problem. Like, this is because the law says you have to have this and you have to have this and you have to have this, and the more stuff you put in, the more you're going to look like you comply with the law. So a lot of times, that's really the driving factor behind all of this kind of verbosity. All right, I think we're out of time, but I'm going to be downstairs, so I'm happy to talk with you more. But thanks for being a great audience.
Hello, Hope. Okay, before we get started with the second in our patent-themed part of the afternoon, a couple of quick announcements. If you go to any of our talks which are filled to capacity, keynotes and that sort of thing, especially things at Manning and Olson, please note that if you leave before the end of the talk, you won't be able to get back in, most likely, as somebody will have taken your place. So look out for that if you don't want to miss the end of a high-capacity talk. Don't leave before the end of it. A couple other things to touch on. If you want to hang up anything on the walls of the conference, that's cool. We're all for that. But get some blue tape from us. You can use the blue painter's tape to attach things to the walls. Nothing else. No Scotch tape, no masking tape, no audio tape, anything else. Just get the tape from us, and we'll give it to you. Beyond that, we're about ready to get going. So I'm happy to present Ed Ryan with Can You Patent Software.
Hello, everyone. Thank you for sticking around if you're here for the second part of the patent double feature. And if you are new, that's great, because I'm going to talk about some of the same stuff that Charles talked about, and it'll be fresh for you. So the basic thrust of this this talk is kind of to analyze what happened last month when the Supreme Court came down with the Alice versus CLS Bank decision. Because it unsettled the practice of patent law, and especially how software patents are approached. So the quick answer to the question of can you patent software is yeah, you still can. There are very vague rules currently about what you can and can't do when you're patenting software. And they got vaguer last month. But just to give you a quick idea of what I'm going to be talking about, I'm going to start off to talk about the basics of patent law, the foundations of it, where it comes from, and then we're going to talk specifically about software patents. I'm going to give you one specific example of a patent that we can all kick for a little while, and then we'll get into exactly what the legal requirements for a software patent are these days. So the basic idea behind software patents, these are the existence of them comes out directly from the Constitution, giving Congress the power to regulate intellectual property, not just for software, but for copyrights as well. Basically, the concept being in order to incentivize people into creating awesome new things, we give them certain rights over them. And the idea here, it comes out of sort of a philosophical background of if you put your labor into something, if you create something, you should have some kind of right to that thing. And that is very easy to see when it comes to like developing land or making a widget, but it's a little bit harder to see, and it's a little bit less of a natural fit when it comes to intellectual property. So the Congress has created a whole set of statutes that provide a framework for this. And as Charles discussed earlier, a patent is ultimately an exchange. The goal is if we're going to get the benefit of this creative effort, society wants the actual meat of that. They don't just want you to work in secret and create your fantastic widget and then never know how it was made themselves. So the trade that happens is the inventor gets this right, this monopoly right for a period of years, and in exchange, they explain how they did it. Currently, the patent term is 20 years from the date of filing, so it's a pretty long term if you keep up your maintenance fee payments, and you get an awful lot out of it. But the question arises of whether this actually promotes progress. And it's only until, say, the past couple of decades where that was even a question. It was kind of a given. Everybody just accepted that patents were amazing. To use a quote from I believe the Secretary of State from Japan in the 1920s, "What is it that makes the United States such a great nation? We investigated and we found it was patents, and we will have patents." So until very recently, it was common wisdom that patents were the be-all and end-all of how you drive, like from a policy perspective, how you drive innovation in a country. But there's a very legitimate point, which is that people would still make stuff even if they didn't have patents. There are a variety of other motivations beyond, the pure profit interest. And even then, invention has pecuniary rewards, even if you don't have an exclusive monopoly to it. The open source movement and hackers or makers are a great example because they're motivated by something other than the almighty dollar. They're in it for passion, for curiosity, or whatever. But there are fields in which it's not so easy to get in, right? Part of the charm of our culture is that it's very accessible. Anybody can pick up a book and learn how to program. Anybody can pick up a $30 soldering iron and learn how to make something out of electronics. When you get into more abstract things and harder to develop things, pharmaceuticals are a great example, it's harder to make the case that people would put as much effort into innovation and developing new technologies in these fields because they are very hard to produce and very easy to copy. Once you've got this, and you have to let people know what chemical they're putting in their bodies. Once you've got that chemical, other people can step in and make it, even though it may have cost you tens of millions of dollars to get to the point to figure out, okay, this is the chemical that cures headaches or whatever. So it's harder to accept that people would, out of a sense of passion, produce new pharmaceuticals. But every single field has its own set point. And so specifically when we talk about software patents, we have to look a little bit harder because we all know for a fact that software develops at a very rapid pace even outside the context of patents. People will do everything they can to get away from patents in the world of software. So what I have personally found is that the biggest effect that patents seem to have is they reduce transaction costs. Transaction costs being a term from economics, which means once you've got, what does it cost in order to do business, right? I'm a patent attorney. I talk to inventors. I talk to people who are, in it for the first time. They've got this great idea, and they don't want to talk to anyone about it. And when you've got a great idea and you want to make it and you want to see something happen, not talking to anyone about it is the worst possible thing you can do to actually make it happen. But they don't want to talk about it because they're afraid of somebody taking it. And writ large, that affects absolutely every single part of our economy. When people are no longer willing to talk about their things and come out and openly develop them, you end up with a lot of effort gets wasted on secrecy, and there's a large opportunity cost in that you don't get the feedback that you might need in order to complete your development. So the question then becomes, what can we patent? And this is set out in the statute as being whoever invents or discovers any new or useful process, machine, manufacture, or composition of matter. And software is usually claimed as either a process or as a machine that's sort of designed to accomplish something. So if it's not one of these, four things? If it's not one of these four things, it's right out. But software, from the cleverness of the draftsman, they write it in terms of something that looks right. However, there are exceptions to those four statutory categories of patentable subject matter. And the courts, and starting in 1854, the courts have recognized certain categories of exception. You have laws of nature, natural phenomena, and abstract ideas. So laws of nature comes out of things like you can't patent the propagation of electromagnetic waves, right? You can't patent radio, or at least you can't patent the concept of radio, the concept of radio waves propagating through space. That said, if you had a device that in a specific way manipulated electrons to create radio waves propagating through space, and you patent that device, you're not patenting that law of nature, you're patenting a specific object. Natural phenomenon, kind of a similar thing. You can also, for example, you can't patent a cat, right? Cats have been around a long time. Nature made cats. If you genetically engineer your own awesome super cat, you might be able to get a patent on that. But when we talk about software patents, the key is abstract ideas. Software patents often get couched as abstract ideas when the courts talk about them, because software isn't really anything, right? You can't put your hands in some software. You can't hit somebody with software, right? So ultimately, we have to find some way of phrasing software. So if we want to avoid this, it has to not seem like an abstract idea. Now keep in mind, that said, processes are patentable. So the question now is, how do we tell which one's which? And it's worth asking why software is different. Because of all, when you talk about an invention, you're talking about somebody who's expending effort and creativity and trying to make something new and awesome happen. Okay? So why should it be so different when you're talking about I made this radio versus I made the software for the radio? My personal belief as to why software is such a big deal for us, and why software patents are such a big deal for us, is because software is kind of unique in that, well, it's not. Let me take a step back. It's not unique, but software is a new field. The past 4 decades, questions of software have really been popping up in the legal world. And because it changes so rapidly, you end up with situations where things that you didn't really expect to have an application now suddenly do. And so you can patent something for what you intended, and then a little bit later find that it's useful for something completely different that you had no conception of when you made it. In addition, because software as an industry is so new, when you patent the basic building blocks of an industry, you essentially own that industry. And you can't, other people have a lot of difficulty getting in after that point. And on a more direct, scale, it kind of offends core beliefs in our community. Open source is all about sharing. Hacking in secret is no fun. We like to talk about what we do. We like to share what we do, and we like it when other people do awesome new things with what we've done. And so the concept of patenting something on that scale, it really sours the whole mix. I should note at this point that we are talking in addition about, when we talk about software patents, we ultimately talk about a lot of different things all at once. We talk about novelty, we talk about obviousness, and we talk about the bare concept of software patents. And different people have different problems with this at each different step of the way. Most of the time when you hear about software patents, people are really talking about obviousness, because that's what really gets to us. When we look at something and say, I could have done that. That's nothing interesting or new. That's just, a kind of workmanlike addition of one thing to another thing. There's nothing there. But what I'm talking about here is on a very basic level. Is software itself patentable? So software patents and the attempts to patent them, or software and the attempts to patent them, have been around for a very long time at this point. In my scale. They've been along longer than I have. The Supreme Court found in 1972 that numerical algorithms and mathematical formulae are unpatentable abstract ideas. And that sort of sets the tone, right? They came right out and said, algorithms are abstract ideas. So now we have to find something about software, because if you just take it like that, well, kind of every piece of software boils down to algorithms. So in 1982, the Supreme Court took it in the other direction, which is that somebody patented, this is the case Diamond versus Deere, somebody patented a process for curing rubber, which involved a computer that calculated the exact right temperature and time at which you pull that rubber out, at which point it's no longer goo, now it's a rubber doodad. And because that software was implemented on a computer, and it was implemented in this useful technological process, that software was patentable. So I want to emphasize, though, the point that eligibility, that what I'm talking about here, abstract ideas, whether those are patentable, whether software is patentable, is different from the question of novelty. Because there are many, many bad patents out there for a variety of different reasons. And just because something is obvious doesn't mean it's not eligible in the statutory sense, right? So here's an example. This is a patent for a doubly linked list. It was filed, I believe, in 2004. It issued in 2006. So I would like to get a little bit of feedback here. Were doubly linked lists invented in 2004? Well, somebody here up front invented them in 2003, and he should sue. Okay, I'm waiting. All right, great. So I'm just going to give you an idea of what this patent talks about. Because can you read it on there? Probably not. No. A computerized list that may be traversed in at least two sequences comprising a plurality of items that are contained in a computerized list. That's 1, 2, and 3 there. And then a primary pointer and an auxiliary pointer for each of the items. And then there's a bunch of verbiage. Basically, the primary pointer takes you on a first sequence through the list. The auxiliary pointer takes you through a second sequence of the list. And the idea, the way it's phrased, is it's very general. So you can go basically any path through this collection of items, including just backwards. And so if you have a textbook from before 2004 that shows linked lists, you will see a doubly linked list that reads on this patent. So I think we've determined now whether this is new and non-obvious. I think we all know pretty clearly that it was done before, and so it's a bad patent. We can say that with some confidence. The question of the day, though, is it eligible subject matter for a patent? And I want to get your opinion on that. Based on your layman's knowledge of what a software patent is this eligible subject matter for a patent? The primary pointer is not defined.
What is a pointer?
It's probably defined in the spec. Yeah, I expect so.
Didn't somebody once try to invent if statements?
I don't know if somebody once tried to invent if statements. I think probably we have them. It's no problem, but if we could keep most of the questions towards the end, that would be great. So we agree, it's not new, and the question is it eligible? And so we have to look, does software fall into one of those exceptions? Because we can characterize software as being a process or as a machine, so it meets the first test. The exceptions, as I said before, are laws of nature, natural phenomena, and abstract ideas. And software hinges on that concept of an abstract idea. Intuition tells us that this is a very abstract idea. It's just a data structure. Intuition doesn't always get us where we need to go in the law. Unfortunately, the courts have not given us a clear idea of what an abstract idea is. There are two courts in play here. There's the Court of Appeals for the Federal Circuit, and there's the Supreme Court. And the Court of Appeals for the Federal Circuit is a very specialized court. They deal with specific questions, not just patents. They do with like a couple of other things, but they're all like federally created questions. So the Federal Circuit is kind of in the trenches. Their goal is to make the patent system work. And I've detected a laugh. It is their goal, and they take it very seriously, right? They are not trying to mess things up. The problem is that every time they come up with a workable, reasonable rule that anybody can pick up and apply, the Supreme Court shoots it down. Because the Supreme Court tries to be pretty minimalist. They don't want to say very much. They want to keep it as open-ended as possible and make people think, is this an abstract idea? For a long time, actually, the Federal Circuit kind of ran unchecked. It's only recently, in the past 5 or 10 years, that the Supreme Court has started coming in and saying no. So in the past couple of years, here are a couple of examples. The Bilski case came down in 2012. Bilski dealt with, it was kind of an escrow thing, basically using a third party to guarantee an exchange, something like that. And the Supreme Court found it to be an abstract idea. But in doing so, they shot down the Federal Circuit's machine or transformation rule. The machine or transformation rule was a very easy to apply test. We have a process or a system or whatever. Is there some actual device involved here? Or does it create some transformation in the world around it? So for example, the rubber case where they were curing rubber. That software made a transformation take place in the real world. In the machine or transformation rubric, it made my job very easy as a patent attorney. All I had to do was add using a processor to one of the steps in, like calculating using a processor, and I was done. So I was a little disappointed in Bilski, personally. And it kind of unhinged everything because the Supreme Court just came in and said, no, it's an abstract idea. The question should be, is it an abstract idea? Not machine or transformation, though that's instructive. And so as a result, nobody really knew what the rule was. And inevitably, we came up with another case, the Alice case, which was just decided last month. The Alice case was another kind of financial transactions case. If you were here earlier, Charles talked in some detail about those claims. And the Supreme Court this time came out with a test. They came up with something that at least sets up a framework, but it still doesn't really define its terms. And so you go through, and we'll get into the test in detail in a few minutes, but you go through and it still doesn't get you where you need to be. And here's the test. Number one, you have to ask, is the claim directed to an abstract idea? And if it is, number two, is there something that makes the claim significantly more? Significantly more, I don't really know, than that abstract idea. And what's important to note here, which is, and I apologize for reading off the slide, but this is important. Even if you have an abstract idea, you can still get a patent. That means if you can find something to tie your claim down to that gives it that little something extra, you still get to walk away with a patent. And the Supreme Court gave some examples of what an abstract idea could be, based on their own case law from the past. Number one, idea of itself. Number two, fundamental economic practices. Both Bilski and Alice came under those that one. And number three is mathematical relationships and formulas. So talking about an idea of itself, this is kind of poorly defined, but the gist of it is, if you have this idea that, and if your patent's claim for this idea covers every single possible embodiment that could be made out of this idea, then that counts as an abstract idea. In my personal belief, I think that doubly linked list would count as an idea of itself. Even though it has the word a computerized list, I think it's pretty clear that you cannot implement this kind of data structure in any way now because of this patent. For fundamental economic processes, the impression I got for this type of abstract idea is that it's an abstract idea if you can reduce it to a pithy one-liner. Bilski was about hedging. Alice was about a third-party transaction. It's sort of like if you can boil it down to second-grader language, hedging, I'm not okay. If you can make it short, then it doesn't count. Even if all you might have seen the Alice claim in the Charles's talk. If you've got pages and pages of claims and it boils down to you do a thing to some stuff, it's not going to be enough. And just as a little side note, these two big software cases were both specifically financial cases, so we don't have a lot of data for other kinds of software. And then finally, mathematical formulas. This is pretty simple. There was a case where the only new thing in the case was they came up with a new formula. Everything else was the same. It was basically finding a trigger for some alarm, and they had a new formula for it. But because it was just a formula and that was the only new piece, the rest of the stuff that was kind of material, maybe substantially limiting stuff, didn't really count because that was all old stuff. So as I said earlier, even if you have an abstract idea, there's a way out. And your claim needs to have that something more. The court gave specific examples again. Without setting some general rule, they gave these examples and hoped you could sort of color in the rest for yourself. An improvement in any other technology or technological field, that was for example, the rubber curing. That was such a substantial improvement in the field of curing rubber that even though you may be able to couch that claim as an abstract idea, it had enough other stuff going for it. An improvement in the functioning of the computer itself, which is something we're going to talk about in a minute. And then claims with meaningful limitations, with no idea what a meaningful limitation is. So improvements to other technology, like I said, curing rubber, that's pretty good. It's worth noting that Deere's claim was very clearly directed to a mathematical formula. It actually included, it's called the Arrhenius equation that sets the ideal time for curing rubber. But the equation was old. It was the software and the implementation and the effect that was new. Improvements to the functioning of the computer itself. This is one thing that did not come out of the court's case law. And to me, it's really, really astounding because that's ultimately what every piece of software is for, is to improve the functioning of the computer in some fashion. I have no idea how that's going to play out in the law. And, again, as a patent lawyer, I find this one particularly gratifying. I'm looking forward to that. But when you get right down to it, you'll notice that every time I listed something, or almost every time I listed something, I followed it up with, and I don't really know what that means. Because nobody really knows what it means. It's a hard thing for serious legal scholars, not that I'm claiming to be a serious legal scholar, but it's going to be impossible for patent examiners. Out of curiosity, do we have any patent examiners in the audience? Great. Patent examiners, all credit to them. My job is to make their job as hard as possible. patent examiners are generally hired straight out of college with no legal training whatsoever. You know, they go through kind of a patent boot camp, and they're given sort of a basic rubric for examining patents. And there's this giant manual that they get to flip through. But there's no, you know, they're not hired for their ability to determine what an abstract idea is. Right? They're not hired for their ability to figure this out. Nobody on the planet is. So ultimately, the Patent Office is going to have to figure out some way of systematizing this, some way of breaking the concept of an abstract idea down into at least, you know, certain red flags that people can look for. But the court was clear at least about one thing. Saying that it's on a computer is not enough. They said this very explicitly. You can't just have an abstract idea and hang a computer on it. And you can't just take an abstract process and then say, go do it. Right? There has to be something more there to it. And the reason the court wanted to do this is to avoid what it called the draftsman's art. They don't want particularly skilled patent attorneys to be able to walk in and just use, not even particularly skilled, just patent attorneys who have been around long enough to know there are some magic words. Under the Federal Circuit's test before Bilski, the machine or transformation test, there were just magic words that I could use, right? And suddenly this abstract idea is no longer abstract. Now it's got a machine. I think, well, the Patent Office is currently struggling to figure out what's going on. They released guidelines on June 25th. If you're especially curious, I've got a website up. It's got a link to their guidelines. The guidelines basically just repeated the decision in Alice, and that's fine, right? It's not their fault because legally that's what they are bound to. They don't really get to make their own law. So they have to wait for somebody else to figure out what the answer is. But taking all of this and taking it back to our example of the linked list patent, again, I think it's pretty clear that this is an abstract idea. There's nothing here. And the court was clear that just being a computerized list is not going to cut it. But as an academic question, if we wanted to save that doubly linked list patent, if we had come up with our own brand new doubly linked list, since apparently those having happened before doesn't bar patenting them, how would we do that? Putting yourselves in my shoes for a moment, the court gave us a couple of different ways of getting around the fact that you've just got an abstract idea. If we were to tie it to a specific industry, so if this was suddenly the rubber curing doubly linked list, that would get us there. And if we were to give it some meaningful limitations, that would do it. I'm not really sure what a meaningful limitation is still. Oh, and of course, doubly linked lists improve computers functioning. And I hit the wrong key, and there we go. Hey, great. So ultimately, we're kind of, we don't really know what's happening. In terms of actual practice, the Patent Office hasn't changed much yet. And I don't think they're going to change much yet. But even so, in a certain way, the Patent Office no longer has this easy test to apply. They can no longer say, well, it doesn't have a machine, it doesn't have a transformation, so you don't get a patent. Now they have to actually show to me in some way that it's an abstract idea. And I have ways of getting around it that the court gave me. So, as of the past few weeks, nothing's really has changed. In fact, nothing at all has changed. The Patent Office is still applying the machine or transformation test that the Supreme Court shot down years ago. There was kind of a weird quirk, and I don't know if this was an individual examiner or office policy, but I can't use the word processor anymore because that might be a human being. And that's where we stand. We're still figuring things out. But ultimately, software patents are not going to go away. I don't believe that any amount of reform effort is going to change that for a couple of reasons. The Supreme Court has already clearly stated that at least some kinds of software patents are eligible. It's a very vague test, but there are ways that are officially sanctioned to do this. And on a legislative level, although there are always efforts to reform the patent law, I don't think you're ever going to see a new statute that excludes software patents. The software industry is just too huge, there's too much money invested in it, and the patents themselves are too valuable. There's this concept in constitutional law called a taking, which is what happens when the United States or some government, maybe a state or a town or whatever, takes over a piece of your land and then has to compensate you for it. If the government were to completely invalidate software patents as a class of thing, I think there would be a strong constitutional argument that the government would then have to pay the fair market value for every single one of those patents. I don't see it. And that is where we stand. So I've got plenty of time for questions. And if you want to see links to various things that I mentioned, like the Alice case, the decision from the Supreme Court, the current patent office guidelines, a link to that patent if you want to learn how to, do a doubly linked list, and eventually, a link to this talk itself. That is where you can find it. If you want to ask a question, there is a microphone over there. Well, your voice is going to be on video. So if there are any questions, I'm happy to answer them. Okay, Guy, if you want to yell it from there, go for it.
Question.
Sure.
Are people not allowed to implement linked lists? And if they did, are they now eligible to be sued under that patent?
So the question is, are people not allowed to implement a doubly linked list? And if they were to, would they get sued? The answer is no and no. On the face of this patent, which is a valid patent that currently exists, and somebody owns it, no, they own doubly linked lists and every other kind of wiggly linked lists out there. Well, that depends. Whether you can implement a linked list depends on how much you respect that patent. Your second question was, will you get sued? The answer is almost certainly no, because this is such a clearly bad patent that they would be wasting their money. It would be nuts for somebody to try and enforce this patent. And I should say that is not legal advice. I'm not recommending that you go implement a doubly linked list. And if you do, it's not my fault if you get sued. As a reasonable human being, however, I really don't think that it would be a problem. And I think that every single person who's taken an introductory level programming class or has done it on their own or independently invented the doubly linked list. There are plenty of people out there who would be in line for getting sued. Yes, sir.
So two common examples of software patents, I think, are Amazon's one-click patent and maybe Google's PageRank algorithm. These are discussed commonly. So with the new tests handed down by the Supreme Court, does it open up patents like these to new attacks? Or since these have been around for a while, are they kind of grandfathered?
Right. They are not grandfathered in. The Alice versus CLS Bank patent was an existing patent, right? And they invalidated it because it was an abstract idea. Now, I don't have the Amazon one-click purchasing patent, and I don't have the PageRank patent in front of me. So I don't know what they actually say. And I don't know whether they have the more meaningful limitations involved. My hunch is that it's going to depend on the patent And again, not because of the particular language in it, but kind of what it's doing. I think it's going to come down to whether they're making some appreciable difference and doing something that's really genuinely new.
Well, I guess then my question is procedurally, these patents have been around, let's say 5-8 years or so.
Yeah.
Amazon goes to sue somebody for infringement. There's a new test. Might these patents be open to more attacks now?
Yeah, certainly. You can always attack the validity of a patent when you get sued. And subject matter eligibility is one of the attacks that you can levy against it. And so, yeah, you would have to look at it. Whether it's an additional attack, whether there's more stuff available than there was before, I can't really say. It was always a possibility to attack it as an abstract idea if it seemed too abstract, right?
Again.
Hey, Ed.
Hi, Alice.
So is there any precedent for patenting or not patenting a novel use of a previous technology or even earlier in history, just like any device?
Sure. Well, okay. So when you're talking about a device and you're talking about, like a microphone, since I have microphones in front of me, that device has a structure to it. And that's one way of claiming claiming an invention. And another way is through a process. So that device already exists. You didn't invent it, even if you find some new way of using it. What you might be able to do is get a patent on a process, a new process that implements this device for some novel use. And if nobody has used a microphone to stir cake batter or to do to go to war, I don't know. If nobody has used the device for that purpose before, then that's a legitimately new process, and you would be able to. I don't know. Depends on the thing. You might be able to get a patent.
Hey there. So thank you for that very informative discussion. But what a whole other aspect of software is that they are also eligible for copywriting.
Yes.
So, and for those copyrights, the processes for copyright and patents work very differently.
Yes.
So my question would be, given that software, this is a question I've actually done some responding on and some writing about. So given that the software already exists, given that it already exists in the realm of copyright, and that it is eligible for copyright, does the case for continuing software patents make as much sense?
Well, this is not the only sort of situation where the realms of intellectual property cross over. There's also substantial crossover between trademark law and copyright. In terms of even just like a sculpture, you can copyright your sculpture, and you can also get a design patent on it. There are lots of places of crossover. I don't think the fact that there's room in copyrights for software removes software from the world of patents, or even makes a very strong case for it, because ultimately what they're protecting is two different things. The copyright is there to protect against your very specific expression of this software, right? You're talking about, I'm writing a new thing, right? It's protected on a couple of different levels. There's the bare code. There's sort of the framework, and copywriting software is very complicated. I do not remember the whole structure of it off the top of my head. But basically, there are different levels of where you can get copyright protection for a piece of software. But patents is looking for something different. In the world of copyright, you're specifically protecting against copying. Somebody who saw what you did and said, okay, I'm going to do that same thing now. In the world of patents, it doesn't matter if they copied you or not. It's an absolute monopoly. And what you get out of that is the know-how. That society gets out of that is the know-how of, now we know exactly how to perform this piece of software. I don't know if that.
Well, I guess I have a follow-up question then. Yeah. Given that reverse in software, unlike many other fields, reverse engineering is extremely common. So you don't have to know how something is made on the details of it. You don't need to know the step-by-step patent instructions that you put in software. It's this code with this data structure in order to replicate something on the back end.
Sure.
So what you're telling me in this case, and we know this from patent trolls as well, is that people, if someone creates a photo sharing site and then someone else says, "Oh, I had this patent for a photo sharing site," even if the code is working extremely differently. So the actual patentable steps are not the same. And when a patent troll threatens to sue, you don't really have the ability to know what they're suing on or taking a look at their patents either. So this gets into patent troll discussions. But the point is, it's not so much that having copyrights on software would invalidate patents on software by the nature of what copyright and patents are, but in the nature of their intended effects of promoting innovation and competition in the marketplace. Do you think that copyright alone enough could do the job?
No. I mean, well, that's my gut reaction. Copyright is a very difficult to enforce thing. If you credit the idea that patents are beneficial to innovation, copyrights don't really provide that. Copyrights protect against copying. And that's really all they, when you have a copyright lawsuit, you have to prove that they actually copied it from you, right? And so that doesn't give you much in the way of protection. And so if you, and I'm sure many of the people here do not, if you sign on to the idea that offering people patents makes them more willing to make new things, then just offering them a copyright is not really going to get them there, because it doesn't give them the same ability to monetize that invention. Okay.
Hi there.
Hi.
I'm sorry if you find this to maybe be a silly question, but I've had this idea, which is I've heard, I don't even know if it's true, but somebody might be able to tell me. W40, that product, that silicone product that you use, well, to make things, well, for whatever you use silicone for.
If they stick and they shouldn't stick?
Yeah.
Yeah.
That I've heard, but actually that the formula isn't patented to the product itself doesn't actually have a patent,
right.
And that is why actually it's very well and nobody actually managed to copy their product. Nothing is as good as it apparently.
Sure.
So by analogy to the situation with software, could you think of any situation in which it would be better not to seek for a patent on a product like that?
Oh, absolutely. That actually comes up quite a bit. The realm of trade secret protection is pretty prominent in the law. And a lot of places do choose to use it because trade secret protection doesn't end after 20 years. If you can keep that secret going forever, you have it forever. Trade secret protection, though, is like each of them has their own advantages and disadvantages. Trade secret protection can go forever, but you have to be really careful. And it involves a lot of it has to be a secret. And you have to be able to show that you are putting forth legitimate effort towards making this a secret. And if you aren't keeping, if you aren't making efforts to keep it a secret and somebody steals it, well, that's your own fault, and the court's not going to give you anything for it.
Yeah, basically the Coca-Cola formula.
Right. I mean, the way Coca-Cola does it, they have that secret formula. They have 3 different. Speculating. There are various different places. They bring the different chemicals together. They mix them together so that nobody has the whole formula. Right. That's the level of effort that's required to keep a trade secret. These days, especially. So people get patents. And frankly, when you have a patent, like I was talking about earlier, it reduces transaction costs. Because once you have that patent, you can license the patent. You can sell the patent. It just makes things kind of easier for you for those 20 years.
Thank you so much.
No problem.
So you said this ruling acknowledges that software patents as a concept are valid, but outlined certain ways in which they can not be validly put together. Did they outline any examples or concepts of what would be a valid software patent?
Yeah, like the one that I kept coming back to was the case of Diamond v. Deere from the 1980s, which was about a piece of software that was used to determine when to stop heating a piece of rubber when it was perfectly cured. And there have been a variety of other cases in the years since then, maybe not necessarily getting up to the Supreme Court level, but at least at the Federal Circuit level, acknowledging software patents as being something that they exist and they're okay to have. So I think that we have managed to reach a graceful dismount here. If there are no more questions, thank you all for coming.
Hello, Hope. We've got some time yet until the next presentation, but before then, I just wanted to remind you all of what it was like to watch defrag happen on DOS. And you would see all the little blocks, and you would see the data moving from all the blocks to the empty spaces, and it would efficiently fill in the empty spaces. We want to try and do that with the seats. So if you're sitting near empty seats and it's possible for you to maybe move in and fill those and open up other strings of seats for everyone coming in, that would be very much appreciated. And also, if you are coming in, look around for empty seats. Don't be afraid to ask people to move out of the way so you can get to the empty seats. And if any fights break out, that's your own problem. Okay, we've got a couple of minutes until the next presentation, but until then, enjoy some more music. Hello again, Hope. Very, very good crowd here. Okay, I've got a few brief announcements to make before we get on to our next presentation. The important one to know right now is that this place is full. So if you can find an empty seat, take it. If you can find some standing room and they're still letting you in, take it. But if you leave before the end of the presentation, you will not be let back in because we just won't want you here anymore. A couple other things to know about, just some general con stuff. If you want to stick stuff to the wall around the conference, there are lots of posters of all types around. That's fine, we're all for that, but do not use your own tape. Use our blue painter's tape. If you go to our security desks or info desks, they'll have some there and they'll just give you some because that's the kind of tape that we can use on these walls in this hotel. So yeah, take care of the walls and we can do this again next time. Speaking of taking care of things, conferences have what's called the 5-2-1 rule, if any of you are familiar with that. And if you're not, I'll explain what it is. It means every day of a conference, you should get 5 hours of sleep, 2 square meals, and 1 shower or bath. This is the way you take care of yourselves and those around you. So we're I think just about at capacity. So without much further ado, it's my pleasure to present HTTP Must Die with Parker Higgins and Yang Zhu. Ladies and gentlemen.
HTTP must die. Hi, everybody. I'm Parker, and this is Jan. We work at the Electronic Frontier Foundation. I'm an activist there, and she's a technologist. And today we're going to be talking about HTTPS and web encryption and the many shortcomings of unencrypted web protocols. Thank you for coming. And just quickly, do people here know what the Electronic Frontier Foundation is? Where you work?
Woo! Great. We can't actually see you, so it's okay if you don't raise your hands.
EFF, we do a lot of things around preserving people's privacy and anonymity online, and so we'll talk a little bit about the things that we do in law and in activism and in code to make people's online and technical experience a little more private.
All right, so how many people here have ever felt insecure? Because you're lonely, you lost your job, you're not happy with yourself for some reason. So I've never actually felt any of those things, but the other day I was visiting Quora.com, which many people visit, and I noticed they're serving their login page over plain HTTP. And that's bad, because even if you're sending things over HTTPS, the attacker can modify the form and then change the target to whatever they want. So in their case, it was even worse because they were actually just sending usernames and passwords in plain HTTP. Shame on them. And by the way, it's 2014. This went out of fashion in like 2001. And they're asking me to use Flash. Ew, right. You guys are at Hope. I'm pretty sure most people here know why HTTP sucks. But to go over it again, there's no data confidentiality, so the person at the coffee shop or the person sitting next to you right now can read what you're sending over the wire. No data integrity, so they can tamper with it and you can't detect anything. And there's no server authentication, so if you're visiting httpquora.com, it could be anything. So given all of this, what?
Could be Quora.
Could even be Quora. Oh my god. So given all of this, why are we still using HTTP? Okay, so people say HTTPS is hard. It's not actually true, but people might say certificate authorities are gross. They kill elephants. They are people we don't trust. They can be corrupted by governments that say issue a certificate for something. And we've seen evidence of this in the wild. So that's a real concern. Certificate authorities suck a lot. Mixed content is bad. So if you're a news site and you've switched over to HTTPS, you're probably serving ads that don't support HTTPS. So you have to support HTTP, and then you have HTTP JavaScript on an HTTPS page, and then it's no security guarantees anymore. Many advertisers don't yet support HTTPS, and that's why news organizations have been slow to transition to HTTPS by default. And if you're using a CDN, sometimes Alchemy, for instance, they can charge extra for HTTPS because they say, Windows XP doesn't support SNI, and so we need extra IP addresses, and so forth. And so if you have set up HTTPS, you have to remember to renew a cert. So I recently saw a statistic that something like 40% of SSL certs in the wild were set to expire within a few months. Great, let's go on.
So let's start the talk with part one. Why are we interested in HTTPS? Why do we start there? And I think the obvious answer is because we know they are interested in HTTP. This slide is a Snowden slide. Of course, it's been in vogue for a year now to have slides that contain images of slides, and we will not break from that trend. We know that the NSA is interested in HTTP because they said that. HTTP it touches almost everything that users do, and we saw this in the X-key score leak, and more particularly, we saw that they drill down to search terms and news sites. And here Glenn is quoted as saying, as one slide indicates, the ability to search HTTP activity by keyword permits the analyst access to what the NSA calls nearly everything a typical user does on the internet. So this matters a lot. And it's important to note that HTTPS and the commitment to HTTPS doesn't stop at the lock on the user's browser. You have to be encrypting the whole way. This, of course, is from the muscular leak. I think most people will have seen the evil smiley by SSL added and removed here. And that comes from a failure to be using HTTPS or encryption along the whole path, in this case between data centers. And when you've got an agency with a footprint as large as the NSA, that actually matters.
So how many of you have seen this article from The Intercept? So I know Michael Lee, quite a few, I can't really see anything, but can kind of see some hands. So Michael Lee, who's in the audience, actually works on The Intercept, and I'm sure can tell you all about it. But anyway, so they published this article that was really shocking to us a few months ago that says NSA has these servers set up to potentially implant millions of devices with malware. That's pretty scary, and that's a lot of devices. So how does HTTP traffic enable this? So here is a slide within a slide from the NSA's Quantum program. So what you see here is a diagram of the target, which could be, me or you or Parker or anyone here, logging into their Yahoo Mail account because maybe it's like 2008 and you were still using Yahoo Mail. So they log in, and Yahoo Mail, maybe at that time, isn't HTTPS by default, even though it does a 302 redirect or something. The NSA server the NSA server can see that they're going to Yahoo. And this sends a signal to what's called a Fox Acid server. And the Fox Acid server does the work of sending back malicious packets to the user's devices, spoofed to look like Yahoo packets. So in essence, by putting these packet injection servers at strategic geographic locations, they can exploit this race condition and get to the target's computer before the real Yahoo packets. And this packet injection will exploit some sort of vulnerability in browsers and implant the malware. And this is quite scary. So you might be asking, millions of computers, maybe they're doing sort of targeting, targeting people that they think are suspicious. So what would they be using for targeting? And it turns out they're using things like cookies, like Google cookies, Yahoo cookies, etc. Because many services like Google, even if they're using HTTPS by default, they're leaking your identity all over because they have not secured cookies. So if you don't set the secure flag on a cookie, as many of you know, a man in the middle can say, I am google.com, send me all the cookies for google.com. And they'll read all your Google cookies, which are really unique. And they can even set cookies for you. They can say, set this cookie for this target so I can look at them later. So cookies are being used as selectors in this case, plain HTTP cookies.
They also use some browser selector. We don't know what codename Silly Bunny is, but we've chosen to illustrate it with a silly bunny.
Yeah, so we asked some lawyers, and no one knew what Silly Bunny was. If anyone knows what Silly Bunny is, please tell us. We'd really like to know. Right, so let's reiterate that. So unencrypted cookies, we used to think cookies are bad because advertisers use them to track us around the web. Now we know they're also bad because they're used as weapons for NSA to decide who to target with malware.
we know that there's a privacy reason and a security reason, but there's also another really important reason to be using HTTPS, and it's maybe one that doesn't get as much attention, and it has to do with censorship. So when we talk about something like the Great Firewall of China, there's a number of ways in which it works, but one of the ways it works is by doing keyword filtering, by drilling down on the contents of a particular web page or of a page within a site. So, you can access a newspaper, but not necessarily the offending article. And the way that HTTPS addresses this is that when you make an HTTPS connection, only the host is available in the clear. So if you're looking at an article, for example, on The Intercept here, a man in the middle can know that you're looking at something on first look, but they don't necessarily know which part of first look or even which article. And there's a big asterisk next to that. So this is true for all sorts of sites. A big example is Wikipedia, of course. It means something different to be looking at Wikipedia than to be looking at an article on something in particular or inflammatory. But the big asterisk there is that is still vulnerable to things like metadata analysis. So if each article has a distinct file size, then you can get around this by just measuring the size of the files that are being transferred, and you can know which article people are looking at. There are ways of avoiding that. You can do padding, but that has pros and cons. The important part here is that this kind of, that HTTPS makes that kind of attack much more sophisticated and expensive. And so even if it's not perfect, it does a good job of protecting privacy. But the censorship angle here is that it forces somebody who wants to block certain keywords to make the decision to block an entire site or not. And we've actually seen this play out. So last year, GitHub was, for a little while, blocked in China. The entirety of GitHub, because it's HTTPS, was blocked because there were, the leading belief is that there were a handful of repositories that had something offensive, and so the only solution, because you can't block those repositories, is to block the entire site. And of course, the Chinese developer community was not very happy about this, and they were very vocal, and they said that we can't do our work. And so there was a backlash, and that backlash forced the hands of the Chinese censors to say, okay, we'll let the whole thing go, including these repositories we don't like. And there's a quote from a prominent Chinese developer who said he compared the blocking of GitHub to trying to catch a mouse by burning the entire house down. Forcing that decision is a good position to be in, to release the mice into the house and say, well, your only option is to burn the whole house down. And that puts the blame really squarely where it belongs, on the censors. So that's an important story with a good conclusion. There's one that didn't end as well, which is the story of Google Reader. Similarly, Google Reader was at a path. It wasn't a subdomain, so it was google.com/reader. And so countries had to choose whether they were going to block all of Google services or allow Reader. And of course, Reader could make connections to other sites. And so people in Iran were able to read the news from around the world by accessing it through Reader. And it made the censors decide, do we want to block everything Google? And for the most part, they didn't. There was 1 or 2 weeks where they did that, but for the most part, Reader was a way to access this news. And this is really important. In Iran, there's estimates that 1 in 3 news sites are blocked. So this was an easy way for people to get around that censorship. And now it's gone.
So here's a quote that I really like from our friend Nicholas Weaver, who I think sums this up really well. The only self-defense from all of these things above is universal encryption, which is difficult and expensive, but unfortunately necessary.
And we know why it's necessary. There's another great advantage. If you run a news site and you turn on HTTPS, the ACLU's Chris Segoyan has offered a bottle of whiskey to any admin at a news org that switches websites to HTTPS by default. So not only are you defending your readers' privacy and security, but also you can get a drink off Chris off of it. So.
I think Chris might be here right now, by the way, so you could even get it from him.
Let's bankrupt him. Let's go nuts.
Okay, so this talk was actually meant to be a really optimistic, happy one, and I think it's going to end up being that way. But I think because it's nice to be cautious, part 2 is called "Not Everything Sucks, Sometimes Probably." Yeah, and we'll see why not everything sucks sometimes, probably, and.
So one way that we look at this, the way that things don't suck, is through the encrypted web report. And this is, it's just a sampling. It's, we look at a handful of websites, services that people use, and we measure how those sites are doing in terms of encrypting user data. And so you can see the first category is, this is just, by the way, this is a long chart that I've just split up into 2. Encrypts data center links, which we saw matters because of the muscular attack. Supports HTTPS, and then the next 2 categories are how well are they doing HTTPS. And then the last one is Start TLS for encrypting user emails in transit, which we'll talk about a little bit later. And really the exciting thing here is that we started with a lot of gray and red, and it's gotten over the last, we've been running it for about 6 or 7 months, it's gotten a lot more green. We've gotten a bunch of sites that have started rolling out HTTPS and doing it well in perfect forward secrecy, and these things, in response to the news cycle, in response to someone pushing on them and saying, your users deserve better. One major example of this was Facebook in, you probably can't see the date, but it's July 2013, so this is the month after the Snowden revelation started, switched on HTTPS by default. It was, most users had it before, but it's by default, and this is a huge amount of connections that are now encrypted. We saw Google made an adjustment, and HTTPS protects not just the contents of the page, but also if you go from an HTTPS site to an HTTP site, there's an extra measure of privacy added by your browser will blank out the referrers. So in Search Engine Watch, they're just upset that they stopped getting keyword data, but for users, that's actually an extra level of privacy.
Oh, by the way, the timestamp on this is September 2013?
Yeah, September 2013.
Wow,
so
thank you, Snowden.
Yeah, the Snowden effect.
So it's not just web browsing. So there's also email, and email SMTP can optionally use an encryption